Glenn Greenwald is going to come and talk to us about some of the constitutional issues that Obama's dealing with. And every time I read Glenn, I don't want to believe it, but damn it, he comes with the facts, and it's kind of depressing. Glenn, welcome back to the Young Turks.
Great to be back. Hope to be able to depress you a lot.
So, Glenn, you know, we got the right wing screaming their head off saying, oh, I can't believe he's going to do any kind of trials in federal courts here for Khalid Sheikh Mohammed and 4 others. Your concern is in the opposite direction, isn't it, about the trials that are not going to happen for some of the people. So can you lay that out for us? What are the different trials that are and are not going to happen for the detainees in Guantanamo?
Sure. The part of the decision that Eric Holder announced last week that received all the attention was the fact that 5 individuals who we basically want to imprison for life or put to death will receive a trial in a criminal court the way that all people who we want to imprison or put to death are entitled to receive one. And the part of the opinion that was much more significant that got much less attention was the part of the announcement that said that 5 other individuals who we want to imprison for life and we're accusing of terrorist acts are going to be denied a trial. They won't be allowed into our court system. Instead, they'll be put before military commissions, the military commissions that were created by the Bush and Cheney administration. They've been modified a little bit, but they're essentially the same tribunals that the Bush administration used to such controversy to try and imprison terrorist suspects without a trial. And so what essentially is happening is that there's a multi-tiered system of justice that's now being set up where some people get trials. If the administration thinks they can convict you in a real court, they'll give you a trial. If they think that they can't convict you in a real court because they don't have enough evidence against you, they'll put you in a military commission where the rules are much more favorable to the state and due process is much more restricted. And then for people that they think they can't win against either in a trial or a military commission, they'll just detain those people indefinitely without charges of any kind. And so it's really not a system of justice. It's a system of show trials where the state is designed and ensured always to win in advance.
So, Glenn, what is their justification? Because, you know, when you look at it from a legal perspective, and I want to really get into the details there in a second, because I think it's interesting what the distinctions are. But what's their justification for having these different levels for the different guys?
Well, the Bush administration invented legal theories as to why they were entitled to abduct people out of their homes and off the street and keep them in prison without giving them a trial. One of the justifications is that, in general, in times of war, whenever somebody is accused of committing a war crime, there have been times in history when the United States has put them before military commissions rather than a full trial. Those are very limited circumstances. They're basically limited to situations where there's an active battlefield and an ongoing war, and somebody is apprehended, say a spy that goes behind enemy lines. You can't ship them overseas to the United States. You basically give them battlefield justice. You quickly convene a military commission and they basically pass judgment. They don't have lawyers and they get executed on the spot. That's traditionally how military commissions have been used, or where civilian courts have been unavailable because they were closed or otherwise unable to open, such as during the Civil War. So we've had military commissions in extremely narrow circumstances. They've never been used when we've actually taken somebody not off an active battlefield, but abducted them out of their house or off the street or from their workplace, which is how most of the Guantanamo detainees have actually ended up being detained, where the potential for a mistake or abuse is obviously much higher. So the theory that the Bush administration used, that the Obama administration is now using, is that during times of war, if somebody's accused of committing a war crime, a violation of the law of war, that traditionally that historically we put them in before military commissions, and so we should do so again. And the theory of indefinite detention without trial is that in war generally, when 2 armies fight on the battlefield and one wins, what the winning army does is round up the surviving soldiers from the losing army and put them into a POW camp until the end of hostilities. Now that's not happening here, where, again, picking people up not off a battlefield but out of their home or off the street, but that's the theory, is that in the past we put them into prisoner of war camps without any trial and until the war is over, and so we should and can do that now. Those are the theories.
So Glenn, what are we supposed to do with them? Because a lot of them were just simply fighting us. Okay, some of them, yes, we just picked up out of their homes in Italy or wherever they might have been. But some we caught on the battlefield in Afghanistan. Well, I'm not sure what's wrong with that. I mean, I don't want them to fight us, so I'm glad we captured them, obviously. But what are we supposed to try them for? Being on the opposite side?
Well, I think first of all, there's you have to make distinctions here. There are people in Afghanistan who actually engage in combat against the United States, who are Afghan citizens who we pick up in Afghanistan while engaged in hostilities. That is the traditional prisoner of war situation, and very few people object to our taking those people and putting them into a prison in Afghanistan as prisoners of war, as just traditional prisoners of war, to prevent them from fighting against us until the end of the war. That's not what the controversies are about. That's not what we're talking about. The people that we're talking about are people who were taken far away from any battlefield. They were picked up in Thailand or Indonesia or Yemen or Pakistan and not engaged in the active combat at the time that they were picked up, which we're really accusing them of people who are terrorists, of engaging in and plotting to perpetrate terrorist plots against the United States. We have laws, incredibly broad and permissive laws, that criminalize belonging to a terrorist organization or plotting to perpetuate terrorist plots against the United States. In fact, we even have laws that make it a serious felony to provide material support to any terrorist group. So the courts have been incredibly permissive with these laws. If you get anywhere near an al-Qaeda training camp or anywhere near a plot or even give money to an organization that is deemed by the United States to be a terrorist organization, you've committed serious felonies. And there are numerous people sitting in prison for very long prison sentences who have been convicted of doing exactly that, of essentially fighting against the United States as part of a terrorist organization. Our criminal laws make it very easy to prosecute and to convict people who are guilty of that, and there's no reason not to use those laws and use our real courts if we want to put people in prison for a very long time.
We're talking to Glenn Greenwald of Salon.com. Glenn, I want to break those two up into two different groups again real quick. So what if we capture someone who was fighting us in the battlefield, traditional prisoner of war, but the war never ends? Do we keep them for 8 years, 16 years? How long do we keep them?
Well, I mean, that's a good question. I mean, there have been wars that have lasted a very long time. Obviously, the Vietnam War lasted more than a decade, and already we've been in Afghanistan for more than 9 years. So, there is a conception, at least, that's grounded in real laws of war and international law that says that if you're involved in a war and you capture somebody fighting against you, you can hold them as a prisoner of war. They're entitled to all kinds of rights that we're denying the people in Afghanistan. They can't be interrogated. They are entitled to have international human rights groups or visit them. They are entitled to the full specter of the Geneva Conventions, which we're denying to the people at Bagram. But at least there's a traditional legal conception that says that you can hold people like that till the end of the war, even if the war lasts a really long time. Now, there's a different question, which is it a smart thing for us to do that in Afghanistan, for example, where our imprisoning people without charges has really done more than almost anything other than our killing civilians to turn the population against us. But that's really a policy question. Do we want to tell the Afghan people that we're there to help them and then at the same time sweep people off the streets and put them into prisons for a decade? But the legal issues really come from people that we're not capturing on a battlefield.
So, Glenn, so for the other people that are captured, you say, that we can try all of them in civilian court under these permissive laws against terrorism and that we don't need to use the military commissions at all. Am I correct in that assumption?
Yeah, absolutely.
Okay, now...
go ahead.
So the military commissions, to what degree were they... How did the Supreme Court rule against them during the Bush administration, and why are these any different?
Well, the ruling that the Supreme Court made in 2006 in the Hamdan case with regard to military commissions is a very narrow question. What happened was George Bush and Dick Cheney created these military commissions without any authorization from Congress. They never went to Congress and asked for a law to authorize these military commissions. They claimed that they had the authority as commander-in-chief and as in charge of national security to make decisions about how prisoners of war and enemy combatants are treated, even though the Constitution says that it's Congress's role to regulate how prisoners are treated during war. And so the Supreme Court in Hamdan said one very narrow thing, which is the military commissions that the Bush administration set up at Guantanamo are illegal because they did not get congressional approval. And they also said that under the Geneva Conventions, the military commissions have to be basically similar to courts that we already have set up. You can't create, for prisoners of war, brand new commissions with completely new rules the way they did. And so in response, the Congress, right before the midterm elections in 2006, passed the Military Commissions Act, the purpose of which was to answer the Supreme Court and to have Congress provide the authorizations for these military commissions. And so Congress has now authorized the military commissions, whether they're constitutional or not, whether they provide enough due process, is something the Supreme Court has yet to address. And lots of lower court cases have said that these military commissions are radically flawed. So they've tried improving them. They've changed. The Obama administration has tinkered with some of the rules. They've tried to ban, for example, confessions that were coerced using torture. They've added a few safeguards to ensure better access to counsel and the like. But the question about whether these military commissions, even revised as the Obama administration has done, are still constitutional is something the Supreme Court is going to have to answer at some point in the near future.
So, Glenn, let's go to the Lindsey Graham question, though. When Eric Holder was in front of him testifying, Lindsey Graham came at him with, what do you want us to do, read them their Miranda rights? And that if we haven't read, let's say we capture bin Laden in South Waziristan, if we don't read him his Miranda rights, can we not use evidence against him? Is that inadmissible in a court of law? How do you answer that?
Well, there's lots of court cases that talk about how if the military apprehends people, if there's foreign intelligence gathering being undertaken, some of these rules are less stringent than other rules might be. Additionally, we were able to interrogate all kinds of people for intelligence purposes, and then thereafter, once we wanted to charge them with a crime, you read them the Miranda rights, you give them access to a lawyer, and only at that point can you use the statements. So you can continue to interrogate people that you pick up off the battlefield. You can interrogate Osama bin Laden, but if we're going to charge them with crimes in our federal court, which is something that we ought to do if we want to kill them or if we want to kill them once they're captured, or if we want to imprison them for life, then at any point in time when we decide that we want to start interrogating them, not for intelligence, but for confessions or statements to be used in a criminal court, then sure, we ought to give them the rights that our system provides. I mean, the whole point of why we're fighting this war on terror is supposedly because we're a free country that operates according to rules of justice, unlike the enemy.
So
and
you're
so
saying
if that's true.
You're saying there's a set process where and courts have adjudicated this, where the military captures someone, they have a right to hold him for a certain period of time, interrogate him for some period of time, and then when we go to try him, then they turn him over. At that point, yes, you would read him as Miranda rights, but you've already interrogated him, et cetera, and he's being processed in the system. Is that right?
Right. I presume that if we capture Osama bin Laden, the first order of business is not to try and interrogate him, to get him to make statements that will enable us to convict him in court. We've already indicted Osama bin Laden. We have an enormous amount of evidence against him, regardless of what he says, that will enable us to convict him. The purpose of interrogating him, our concern would be to get intelligence about other terrorists, about other terrorist networks, about pending plots and the like. So nobody's going to care if we're interrogating him whether those statements are admissible. They wouldn't be. If at some point in time we want to start interrogating him in order to make those statements admissible in court, then we ought to read him his rights and give him the other safeguards. Remember, these procedures, Miranda and other procedures that the government is required to abide by, aren't just there to treat criminals nicely. They're there because the court system has said you cannot rely on this evidence that you get from people unless you abide by these procedures. It's a question of reliability of the evidence. And so, sure, if we want to put Osama bin Laden on trial, we ought to make sure that the evidence that we're going to use against him is reliable. And that means abiding by the Constitution and procedures set up by the court.
Glenn, finally on the legal end of it, do they get the same rights as United States citizens, or is there cases or anything else that says no, they get different set of rights?
The Constitution, if you actually go and read it, never makes any distinction between citizens and non-citizens. And that's because what the Constitution really is it's a restriction on what the government can do. It doesn't create classes of human beings and then assign different levels of rights accordingly. Now, the Supreme Court has said that when you're talking about accused enemy combatants who are captured outside of the United States, they may be entitled to less rights because of the circumstances of what you're accusing them of. But the Supreme Court just last year in 2008, when they invalidated part of the Military Commissions Act as unconstitutional, said that Guantanamo detainees have a constitutional right to habeas corpus, and obviously none of those detainees are American citizens. So the Constitution has been repeatedly held by the Supreme Court to apply to both citizens and non-citizens alike. That's
but how
many Americans don't know, but it's pretty fundamental.
But how are we supposed to distinguish? Like, how do I know which citizens' rights? I mean, you're saying all basically, but also the Supreme Court has said no, not necessarily all rights go to enemy combatants. So how do we know what those rights are that we get but they don't get?
Well, I'll give you an example. The rights in general apply equally. But, for example, as an American citizen, you are entitled to enter the United States at will. You are entitled to stay in the United States and not be deported. You have the constitutional right to remain in the country of which you're a citizen. If you are a foreign national, you don't have a constitutional right to enter the country. If you're in the country legally, the government can deport you. It has to give you due process. It has to provide other procedures and meet certain burdens. So there are instances where being a United States citizen confers certain rights that are not available to non-citizens. But in general, the Constitution is a limitation on what the government can do that applies equally to citizens and non-citizens, and the government just last year held that when it said that even non-citizens never entering the United States ever before who are sitting in an island prison in Cuba have a constitutional right not to be held unless they're given an opportunity to enter a U.S. court and contest the charges against them. So that's an example of a pretty fundamental right of due process and habeas corpus that the Supreme Court just last year held applies to non-citizens.
Finally, Glenn, on the political end, if you're in the discussion in the Oval Office and you say all these things, Rahm Emanuel is going to stand up and say to you, so you're going to tell me, Mr. Liberal Glenn Greenwald, that we're going to have these fair trials for guys that we got stuck holding here. We didn't bring them in. We didn't torture them. The Bush administration did. But we're pretty damn sure that they're guilty, but it's going to be a hell of a thing to prove in court. So if we go to court, civilian courts, and they get all their rights, and they walk, that you're going to let us do that and then suffer tremendous political consequences for it?
Well, first of all, the Obama administration claims that one of the changes they made to the military commissions was that they're not going to allow any evidence obtained by torture any longer. So even if there's evidence obtained by torture, then it won't presumably be allowed in the military commissions either. But the main point I would make is what Democrats have spent the last 8 years saying is that torture doesn't work, that if you torture people and then ask them questions, the things they tell you you can't believe are true because they're basically just telling you whatever you want to hear or they think you want to hear to end the torture. So if the only evidence that we actually have against people is evidence that we obtained by torturing them or by drowning them, then I would say that evidence is not reliable and we should not be imprisoning people for life based on it. Presumably we ought to have other evidence besides evidence that we tortured out of people if we really want to believe they're terrorists. And if we have other evidence, we should be able to convict them.
If you don't have it and they walk, you're comfortable with that?
Well, if the only evidence we have is evidence that we tortured other people, we shouldn't be assuming that they're guilty of anything since Barack Obama repeatedly said that torture doesn't work because you can't rely on what it is that you're hearing. So how could it be that if the only evidence that you have is evidence that you tortured somebody, what kind of inhumane person, what kind of monster would want to use that evidence that you're saying is unreliable, that you can't trust or believe in as a basis for imprisoning somebody for life? And, Obama's whole campaign was based on the theory that what makes us better is that we believe in our Constitution and the rule of law, and we ought to have the confidence to go before the American people and say that that's what makes us better and we're going to adhere to it.
Given that he's doing military commissions, given that he's doing indefinite detention, is there a reasonable distinction between Obama and Bush on this issue, or are they just so close that it's that you have to say that he has really not followed through on those campaign promises and basically following the Bush-Cheney model here?
And, I think it's very hard to say that there's no differences between Obama and Bush. I mean, as you pointed out earlier, Obama didn't create the situation, but it's certainly the case that when it comes to questions of due process, one of the most controversial aspects of what Bush and Cheney did was asserting the power to imprison people with no charges or no trial, and that is absolutely something Barack Obama is continuing to do, and that drove progressives and Democrats insane over the last 8 years, claiming it was a war on the Constitution, and absolutely Obama is doing exactly the same thing in that regard.
Glenn Greenwald of Salon.com, thank you so much for joining us. Really appreciate it.
Always a pleasure.
Take care.
If you like this clip, you'll love the whole show. You can watch that at theyoungturks.com.